I can see quite a few people. Hello, Tad. Hello, Simon. Hello, Anna. How are you? Um, I'm going to hand over in just a moment to Ash, who's going to moderate this session on the Renters Reform Act. Really important topic, and I'm looking forward to this. This is going to be interesting. Thank you to everybody for being here. Thank you to everybody who's attending. We've got 65 people signed up today. There are still some people coming in. Just a couple of little tiny housekeeping notes about Zoom. Um, if you want to make a comment, as Tad has just done, hello, just toggle that little blue, if I mean, it might look different on your screen, but where it says to, I think the default on Zoom is to host and panelists. So just toggle it down to everyone, and then everyone can see what it is that you're either saying or asking. And I know, Ash, you're going to explain, but at the end, there will be time for Q&A. If you can use that chat box for putting in your questions, that would be brilliant. So make a note of your questions as our brilliant panelists are speaking, and then bring them up at the end. That would be absolutely brilliant. Ash, I will hand over to you.
Thank you.
Great to have you here. Thank you very much indeed. Let me know when you want the PowerPoint up.
Sure, certainly will. So, good afternoon, everyone. Welcome to the Association of Relocation Professionals webinar on the Renters' Rights Act and what it means for the relocation industry and the rental industry. This legislation represents one of the most significant changes to the private rented sector in decades, and it's already beginning to reshape the way landlords, agents, tenants, and corporate housing providers approach the market. Today's session is designed to move beyond the headlines and explore the practical implications of these reforms, from changes in landlord behavior and compliance requirements to tenant expectations, operational processes, and the wider impact on rental supply and pricing. Some say the Renters' Rights Act improves security and standards for tenants. Others suggest that landlords are becoming more risk conscious, agents are adapting processes and compliance frameworks, and tenants may experience new challenges. My name is Ashley Winston, and I'm the founder of Palmdale Car Finders, and I'm the moderator for this session. You may ask why someone involved in cars, wearing a car shirt, with a collection of model cars behind him, is moderating a panel about property. And it's a good question. It's one I've been asking myself a lot lately. But where I lack in knowledge on the subject, our panelists certainly don't, and I'm honoured to introduce them to you now. First, I'd like to introduce David Smith from Bishop and Sewell. Hello, David. David is our legal expert and will be looking at the legal aspects of the Act. Fun fact about David. David struggled to find a fun fact when I asked him, but he wanted me to know that he went to Paris last weekend, but he spent a lot of his time in a French law bookshop. I think it's fair to say that David likes law. We also have Marco Paverio from R3 Location. Hello, Marco.
Hello.
Marco is going to be looking at how the Renters' Rights Act affects tenants. Something no one knows about Marco is that he is a TikTok star. There's one video of him and his daughter dancing, which received over 12 million views. Next, we have Wendy Young and Donna Ingram, who are from Campions Group, which includes Chesterton's estate agents. Hello, Wendy and Donna.
Good afternoon, everyone. Today.
They will be looking at the Act from the landlord and agent perspective. Wendy walked 50 miles in February in one go. And Donna started her life in dance, much like Marco, but now works in lettings. An interesting journey. And of course, as we met him before, with Dom Tidy from the ARP, who is our technical expert, and he's the one making sure that everything runs okay today. Dom, as he said, will be monitoring our questions. Please do add them in the chat box, and we'll get them at the very end. Thank you very much, Dom. So, David, maybe please start with you. What's your take on this as a legal expert?
Oh wow. I've got slides somewhere, haven't I?
Slides are good.
Slides are a start. There we go. Well, so I mean the important thing to understand is that although we feel like we know lots about the Renters' Rights Act and we know things like Section 21 has gone and stuff like that, there are lots of things we don't really know because as is always the case with any new piece of legislation in the UK, um, the government and Parliament write it in a general sense, but the day-to-day actual detail of it is up to the courts to resolve. So there are lots of things that we're not sure about. So, for example, we know that you can't overbid, so you can't market if you market a property at a price, you can't accept bids over that price. But what we're not sure about is if I get the price wrong, can I take the property off the market and stick it back on again at a higher price 2 or 3 days later? And those are things that the courts will have to fix and resolve. And there are lots of problems like that that are surprisingly impactful. When I mentioned this to civil servants, they were like, "Well, surely that wouldn't happen." But I've had lots of cases already of people saying, "Oh, actually, we put it on the wrong price, and can we now change it?" Or there's two agents and they put it on at different prices, and what are we supposed to do? Um, so that's a problem. And the other problem, of course, is there's things that we may think are true. There's a real Donald Rumsfeld aspect to this thing. There's the known knowns and the unknown unknowns. Um, there's things that we think we know are true, but actually we may find later that the courts say, no, no, that's not actually what the law means. It means something else. And the problem with the courts doing that is that it, in a sense, is retrospective because the courts are telling you what the law always was. And so that has potential risk factors for people. And a good example of that people have seen in the past would be gas safety certificates in Section 21, when we discovered that actually it was a bit of a problem if you hadn't served a Section 20 a gas safety certificate before the start of the tenancy and you couldn't get out of it. So those kind of problems are likely to come up again with the Renters' Rights Act. And that's not just something that affects landlords and tenants, that affects local authorities as well. I was speaking on a local authority enforcement course last week, and local authorities are scratching their heads about the things that they have to enforce, and they're under considerable pressure to enforce. But they're not all entirely clear in every sense what it is that they will be enforcing. And so that's a problem that cuts across everybody, and is likely to cause problems for everybody in different ways. If we could jump onto my next slide with some wonderful tech stuff. Was that my next slide? I think we skipped one there. There one goes. So fixed terms. So obviously we've lost Section 21's ASTs and fixed terms. The government's view is that tenants get certainty, but the problem is they have almost no protection from a landlord who wants to sell or move back in, even if that's slightly constructed. Because of course, moving back in, whereas now it's just for the landlord. Well, under the old regime, it was landlord and spouse or civil partner. It's now landlord, spouse, and civil partner, someone who lives with them as if they were their spouse and civil partner, and then all of the parents, children, grandparents, and grandchildren of all of those potential people. So the width of the ability to move people back in, and of course selling is a fairly sort of widespread problem. Um, Tenants have almost no protection from that. After a year, they've got the year they've been in the property. But any tenant who's looking for some sort of guarantee of occupation beyond 12 months is in major difficulties. Now, I think theoretically it is possible for landlords to contractually agree that they will not rely on grounds 1 and 1A. But obviously, you're going to have to get a landlord to agree to that. That may be quite difficult. Um, and as I've already mentioned, we can't say for sure what the law is about stuff until we go to courts on some of these things. So it's probably enforceable, but I can't give you a cast iron guarantee that will work. So there are real challenges, I think, particularly for relocation agents in terms of securing properties over long-term periods. Now there are ways around this at the higher end of the value chain. So, for example, if you have a rent that's just under £100,000, but you agree that bills are included and that pushes the value over £100,000, that legitimately takes it outside the scope of the Renters' Rights Act, for example. And you can have fixed terms again. So there are things that can be done on the margins, but those will only be useful in quite specific cases. And there's a huge wedge of properties in the middle of the market that just won't be helpfully affected by that. Pets, I think was my next slide. There we are. So landlords can still advertise properties as no pets and refuse pets on advertising, but once tenancies have started, then tenants can ask for pets, and landlords will have to have a reasonable basis to refuse. They are entitled to ask for the details of pets, and they almost certainly will. Most landlords and agents I've spoken to are intending to ask for quite a lot of detail about the pet that you're asking for. And they're always able to refuse permission of a superior lease band's pet. So if you've got people you're trying to relocate who are likely to want a pet or indicate they might ask for a pet, then a flat is unlikely to be a good option for them because most flat leases have a provision in there that will prohibit pets. And landlords are allowed to just rely on that and say, as long as they ask the superior landlord says no, that's it, and there's no further discussion. But the other point to bear in mind is that not all pets are allowed in all circumstances. There's a great deal. I've got myself into terrible trouble on social media by writing about this, at which point people put lots of pictures under there of dogs weeing on floors and other things like that weren't very nice. Um, but obviously, you need to bear in mind that the pet and the property have to match up. There's a lot of problems that landlords are quite focused on the idea of whether they like a specific dog or cat type. And that's not really the issue. One, the legislation isn't about dogs and cats, it's about pets, in it widely construed. And then two, you need to bear in mind that it depends on the nature of the property. There are properties where cats will never be suitable. There are properties where my pet llama would be absolutely fine. Um, but it's about the match of property and pet. And obviously, if this changes the game, and there are suggestions this will change the game in that tenants are more likely to want pets, then that's something that you'll need to weigh into your property finding and matching the right property for your clients to any pet desires they may or may not have. I have to say, I have some doubts about this. I'm not entirely convinced that every tenant is immediately going to turn around and ask for a pet. But the pet advocacy groups reckon that 80% of tenants want pets if they were only allowed. I have doubts about these stats. Tenancy agreements. Landlords and agents are probably rushing now, but they have until the end of this week, in effect, because they've got to the end of May, to regularise existing assured short hold tenancies by providing the information sheet. So I presume many of you have been receiving copies of information sheets, emailed, posted, stuffed through the letterbox. If they haven't been done, then technically, as of Monday, then there is a civil penalty that is potentially payable if the individual local authority elects to levy it. My understanding is most local authorities will levy them with some aggression. So there's a penalty of up to £7,000 if it's not done by Monday. So this is really the end of the line for many landlords and agents. I'm a bit concerned about that. Going forward, all tenancies will need to comply with the new regulations. So obviously, anyone who's trying to present you with an assured short hold tenancy at this stage is in breach of the law because it shouldn't say it's an assured short hold tenancy. It shouldn't suggest it has a fixed term, and there'll be other things wrong with it. Again, local authorities are pushing this point hard, but it's something you should be pressing people on to make sure you're getting the right documentation going forward. I think I had another slide. Do I have one more? Yes, possession. So obviously, there are lots more grounds to obtain possession. So it's got quite complicated now. There are now 37 grounds for possession, covering a whole range of different issues. And obviously, a lot of those are there to replace various things that people may or may not have done using Section 21 notices. There's been a lot of attention. I've talked already about ground one, where a landlord wants to move back in themselves, and ground 1A. But it's worth noting that ground 8 for rent arrears is gone up from 2 months of arrears to 3 months. So if you are having clients and tenants with temporary difficulties, they've got more scope to solve their problem in that they've got an extra month to sort things out before the landlord will be in a position to start pushing them on mandatory possession grounds. But it's also worth noting that landlords will find it much easier to obtain possession to redevelop a property under ground 6. And as we move towards new minimum energy efficiency standards, a lot of landlords are looking at MEES as potentially a way out, to say that they have to meet MEES standards, and we'll be able to use a Section 8 notice citing ground 6 to push people out to do that. So it's worth just bearing in mind that if a property is lower on the energy efficiency rating, a landlord may just use that later as a mechanism to obtain possession. But obviously, there's lots of scope for negotiation because court times are moving up and up and up. They were heading towards 7 months to recover possession. That will rise further, and obviously, it is perfectly open to a tenant to sit in place and then negotiate. And I find increasingly tenants are doing that and are using court delays as a means to stay an extra couple of weeks or an extra month when it suits them personally to do so. I think that's me.
Fantastic. Thank you, David. I generally found that very interesting. It was really
Thank
good
you.
to get the basic line of what the changes are. And of course, there's
Well, that
two.
was only a few of the more interesting ones. There are lots of others, but I thought I'd stick with a few.
Thank you for not taking up the whole hour. We
Yeah,
appreciated it.
I thought someone else might have something to say.
So there's two sides to this. There's the tenant side, and there's, of course, the landlord and estate agent side. Marco, could you enlighten us a bit on the tenant side of things and what the situation with the Renters' Rights Act there?
With pleasure. I think for some context, it's probably worth reminding everybody that really the Renters' Rights Act was introduced as a framework to strengthen responsible rental practices and really improve confidence between landlord tenants and housing associations. It was explicitly targeted towards really low to middle demographics and vulnerable socioeconomic groups. Unfortunately, it now essentially includes some 11 million private renters. And as we often see, sometimes the road to hell is paved with good intentions, and it's possible that this legislation will have some perverse effects on the housing market. We've certainly seen in other markets where excessive regulation of the rental market produces the opposite effect. And so I just wanted to give a really balanced assessment on where we feel we are. I think David makes an important point, which is in the same way, there are a lot of things that we don't really know as part of this legislation. There are also a lot of things that we don't really know about the practical aspect of what it will mean for prospective tenants in the context of the housing market. So I'm just going to share across the next 3 slides and sort of to align with the RRA around rigorous referencing, reduced rental stock, and accelerating rental practices or prices rather, what we are beginning to observe even a month into this new regime. So if we could have the next slide. So we're already seeing that landlords are beginning to apply a greater degree of scrutiny with regards to referencing at the referencing stage to really mitigate the risks of renting. Renting is becoming increasingly more complex for landlords, and really they're being hit on several sides in a sense. So there's increased regulation. There's a limited scope to essentially regain possession of their property, an additional 2% national insurance on rental income. If you have rental income above 50,000 a year, going to 30,000 next year and 20,000 the year after, you have to now report your gross rent and expenses on a quarterly basis through Making Tax Digital with HMRC. So this increase in both regulation and the cost and burden of renting is really having an impact on the number of landlords that are considering exiting the market. In particular, those accidental landlords that may well just have historically the one property that they look after and manage. So referencing may take longer as a result of landlords applying greater scrutiny. It may well be that tenant will need to make an additional effort to provide some form of profiling, demonstrating beyond the usual referencing that they would be good tenants to have. And we're certainly experiencing that on the ground at the moment, where deals are taking longer, where we are seeing more offers fall through, and where tenants might be more inclined, although we do discourage them to do so, to actually put in one or 2 or 3 offers in parallel against properties in order to secure one. That's why we feel it's really important in the context of our own industry to have good destination services support, where we can really provide some reassurances to landlords about corporate tenants coming through, because that's the business we're in, and it's very positive, obviously, for tenants to have that 2-month notice and to have the easier access with regards to pets being allowed. Aside from those practicalities, we live in a market within the context of corporate destination services where, generally speaking, corporate tenants want to stay in a property for a period of at least a year to 3 years. And also it provides some degree of comfort to landlord that eventually they will probably be able, more often than not, to get their property back, because corporate tenants on the relocation side tend to move on to the next assignment as well. If I could move on to the next slides, where we are seeing reduced rental stock. I mean, that's really, again, we've observed the new legislation accelerating some landlords deciding to pull out of the market and really invest in different classes of assets rather than keeping that one property to rent on the rental market. And it's very possible, and it'll be interesting to hear from Chesterton's really, whether over the medium to long term, we might see some development around the sort of the estate type landlords, the Harrod de Wilden type landlords, where more and more renting property will become more of a business for larger organizations rather than individual landlords managing the one or two properties. It's positive in that we may well have a greater degree of choice with regards to build to rent, which we might see evolve over the coming years. And again, it's positive because we might begin to deal more with estate landlords that are much more business and commercial orientated in how they engage in renting. So really, they're removing some of the emotional aspect of renting through an individual landlord. Reduce rental stock because, as I mentioned before, 2% national insurance on top for rental profits, making tax digital, additional risks and costs associated with landlords. At the end of 2026, we're going to see the new database being deployed. By the end of 28, I think every landlord will also have to sign up to being part of the Ombudsman for dispute resolution. Those databases and those schemes have costs, and landlord will be expected to contribute towards that. So whilst it's a free service, it really is a free service for tenants, but not a free service for landlords. And more estate type landlords is both good and bad, of course, because they tend to be slightly less flexible, and so tenants will possibly have a lesser degree of choice when it comes to negotiating a good deal on the rental market. All of those additional difficulties and the reduction in stock really only leads to one place, which is the next slide, which is we are seeing increasingly an accelerated pressure on rents. We saw a spike on rents certainly on prime and super prime markets in London back at the end of Q2, beginning of Q3 2025, when the 1st of May date was first announced by the government in the context of the Renters' Rights Act. And we've had a bit of a lull, as we normally do, in January through to March following Christmas, but we have seen a spike of about 3% in both markets over the last 3 months. We think predominantly as a result of the Writers' Rent Act and the fact that landlords are significantly more restricted in what they're able to do with their properties, and certainly restricted with regards to how they can continue to manage those in the right commercial way. So positive for tenants in a sense, as David has mentioned before, with regards to no bidding war, but again, we don't really know how that's going to work in practice. We will still have Section 13 yearly increases, but that will be much more regulated in how landlords will be able to implement that. And certainly the expectation is that perhaps tenant will use the available appeal that they have to delay rental increases and make it more difficult for landlords to increase rent on a yearly basis. And as I said, the Ombudsman and databases are free services for tenants, but they're not free services for landlords, and there's no such thing as a free lunch, not even on the rental market. And so we expect this pressure on price to continue over the coming months and certainly into 2027. So to conclude on the last slide, what it means for tenant, it probably means greater scrutiny at the offer stage. So setting the right expectation from the start is going to be important. Making sure that you come across as a good tenant is going to be increasingly important. But broadly positive in the context of corporate tenants within our industry, because they are a different type of tenant than the legislation is intended to protect. There will be an evolution on the market. I think we don't know exactly what that's going to look like, but possibly more on the build to rent. Certainly fewer landlords that are managing just the one property and a shift towards more estate landlords. But I go back to David's point that there's a lot of things that we don't really know, but we're speculating at this stage. And it's already having an effect on rental prices. We've seen a spike over the last 3 months of 3%, both on prime and super prime market. And we expect the restrictions on the bidding wars and the restrictions on the increases once a year by invoking Section 13 to have a continued effect on prices over the coming months and into 2027. And that was the bit on tenants. Thank you.
Thank you, Mark. I really appreciate you sharing your expertise there. Really, really good to hear that. Now, I know a lot of the people joining us today, and a lot of people in the industry are very much involved in home searches and that side of the equation. So, Donna and Wendy, what do we need to know?
Well, thank you, Ashley. Yes, well, Donna and I are going to run through how we see landlord behaviour, or how we expect landlord behaviour to shift, how we're adapting as agents, and then really importantly, what does that mean in practical terms with regards to things like process. So in terms of landlord behaviour, I mean, obviously we're only, 28 days into the legislation, but we do expect the Renters' Rights Act, whilst it's a piece of legislation, it has massive impact on behaviour. So historically, landlords have had control with regards to fixed terms, RPI increases and Section 21s. So what we're seeing is a more compliance-led approach. So with the removal of Section 21, we know that possession now has to be justified. So when a landlord chooses to serve a Section 8, that can't be reactive, it has to be evidence-based. So referring back to when David was talking at the very beginning, he was talking about the over 30, so 37 grounds for repossession, and those are evidence-based. So landlords can't be reactive. They need to think about why they want to regain possession and then have the right notice. When we look at things like Section 13s, again, that has to be evidence-based. So we need to be providing evidence that the rental increase is in line with market rate. And as Marco mentioned, tenants have got the ability to challenge that annual rent increase if they think it's unreasonable, and they would do that via the tribunal. But again, there is this real shift in the fact that people can't just suggest things, it has to be backed up with evidence. We expect to see a greater focus on tenant stability as well, where longer term occupancy is the main goal.
So with that in mind, what are we seeing? Apologies, lost my notes. So with property standards, tenants obviously now have much more flexibility over when they can end their tenancy. So landlords are not wanting to be complacent around compliance and condition of their property. Things need to be right from the very start of the tenancy and maintained consistently. And with the pending introduction of the private rented sector property portal and landlord ombudsman, which are scheduled for release later in the year and into next year, there will be increased visibility and accountability. And fines for failure to subscribe to the portal or the ombudsman start at 7,000 and can reach as much as 40,000 for repeat offences. So agents will need to ensure that landlords are registered for both before marketing can even commence. And once these have launched, that would be much better for tenants to have that transparency that they need to ensure they're dealing with a reputable agent and a responsible landlord. So although this is another task for agents to take on, it does actually help us to ensure that we are also working with responsible landlords, even those in instances where we do not manage the property, and is an additional layer of reassurance for our tenants. As Wendy said, we're moving to a much more evidence-based decision-making now. And the Renters' Rights Act has reduced some of the control that landlords previously had over fixed terms and rent increases, shifting things to a more evidence-based approach. This means setting the rents in line with the market and only serving notices on clear legal grounds. There is also less room for subjective judgment, particularly when it comes to offers or tenant selection. It's about fairness, affordability, and transparency. So as Marco was talking about with the referencing element, that's really important because that does give that extra layer of reassurance for our landlords. So although it can slow things down at the beginning, hopefully that does mean for a more stable tenancy once tenants have moved in. The Renters' Rights Act has reduced some of the control, that landlords had. And that means with the Section 21s being removed, that we have to have those clear legal grounds for ending the tenancy. And we have actually seen that although we had a bit of a spike towards the end of April with landlord notices increasing, actually after the 1st of May, we have seen a significant reduction of landlords serving notice. And I think that does go back to that point around accidental landlords. So landlords who needed to make that decision about whether they wanted to continue to operate in the market have made that decision, and it's probably the best thing for them. Whereas now we're hopefully in a period of more stability, and the landlords who have continued to operate, let's hope that they have stable tenants and that they do continue to invest in the private rented sector.
Thanks, Donna. So in line with that shift, the role of the agent is evolving quite significantly. So within Campions Group, which incorporates Chesterton's, we pride ourselves on doing more than just letting properties. And our corporate structure is designed to support landlords, tenants, and corporate partners end to end. This is really about positioning ourselves as trusted advisors and long-term partners as opposed to just agents. So how do we do that? So we do that with accurate pricing from the outset. And I know there's been discussion around, which David mentioned earlier on, about pricing. And then if you get the pricing wrong, can you take it off? It's about robust and consistent processes and a real strong understanding of the legislation. I think what's worth noting with regards to the role of the agent is that there's around 50% of rental properties in London that are currently let without an agent. And we believe that that figure will decline over time as compliance becomes more complex and the role of a professional agent becomes increasingly clear. Proactive management. So a big part of helping our landlords, tenants and corporate partners navigate what is a complex and evolving landscape is the role of the agent. So setting clear expectations early around flexibility, timescales for possession, or indeed picking up on Marco's point, timescales for tenant occupation, and really importantly, the need for compliance. There is a stronger focus on tenant sustainability. So rather than just trying to fill a property quickly, there's more of an emphasis on matching the right tenant with the right landlord and the right property. And this leads to a consistent income for landlords and significantly enhances the overall tenant experience. From a management perspective, the approach has shifted from being far more reactive to being proactive. So this is around the need to make sure that our properties are compliant before they're even marketed and the repairs are handled quickly and effectively. And this is from our perspective where we really add value. In terms of from within Campions Group, we have also introduced really important touchpoint surveys, which is all about capturing live feedback at pivotal points in the journey to make sure that we're proactively increasing the customer experience. So alongside this, from an agent perspective, we've standardized the way we operate, particularly when it comes to things like offers, applications, and tenant requests. This reduces the risks of decisions being challenged and make sure that we're aligned with the legislation. And underlining all of this, I mean, we are a customer-driven industry, is around clear, consistent communication, being transparent with landlords, tenants, and corporate partners from the outset so that we are managing expectations clearly and effectively.
And so what does all this mean in practice? So at Chesterton's, we've created a new team called Tenancy Services. This was previously our renewals team, for those of you who have been working with us over the years. And they are all experienced tenancy consultants who will be handling the annual Section 13 rent increases, tenancy variations, notices, and renewals of non-APT agreements. Interestingly, I mean, it's 28 days in, but we are hoping that it is sort of business as normal, to be honest. Yes, there's a slightly different process that we're having to adopt, but we are having very good conversations with our landlords and our tenants in advance of issuing the Section 13, just as we used to do when we were renewing the tenancy. We're obviously making sure we're being very fair and transparent about the rents that we're proposing. And we so far are seeing that it's very similar to the previous conversations and communications we had before the 1st of May. We will wait and see what happens, but obviously we really don't want to be in a situation where we are tied up in tribunals. We do want to have good relationships with our tenants. We do want to make sure that they feel like they're being treated fairly. So I'm hoping that the approach that we've taken will create some stability, and will be reassuring for landlords that actually, yes, things are a little bit different to how they were, but we're all still carrying on as we were. We have, of course, completely overhauled all of our paperwork. That was a significant undertaking, and I think we were still, the day before, we still had documents that needed to be changed. There was a lot of documents across the group to change. We also got new offer forms, as Wendy explained, standard documents, and of course our AST agreement has been replaced with the APT, which has no fixed term, no end date, and no RPI increases, as well, of course, as that introduction of the new Section 13 notice. Our landlord Section 8 notices are being served by solicitors, and as I mentioned previously, we actually have seen a significant reduction of landlord notices since the 1st of May. This team, the tenancy services team, do still are your point of contact. They coordinate the notices both from tenants and landlords, but then we refer the actual serving of the Section 8 to solicitors where they're needed. The offer process, making sure that we're having a very fair and transparent offer process. We've significantly streamlined and reduced the offer form, so that we're really sticking to the information that's important. Our front offices used to really enjoy all of our bios and photos that we used to get, and we can't have those anymore because we really do want to make sure that we're being very evidence-based in our offers that we're putting forward to our landlords, and really concentrating on the stability of the tenant, affordability, of course, to provide that security for our landlords. And as David was talking about with pet requests, they do have to be considered, can't be unreasonably refused, and landlords have 28 days to respond to a pet request. Tenants can challenge the response of the landlord redress scheme once this is launched or via the courts. Pet addendums should be included in the tenancy agreement or added mid-tenancy to protect both the tenant and the landlord. Notice management, of course, has been changed. And as I said, we are outsourcing our landlord Section 8 notices to ensure that we're always compliant with that. And ahead of the legislation, we saw that increase in landlord notices, but post 1st of May, we did see a spike in tenant serving notice. That actually, over the last week and a half, has stabilised back to pre-1st of May levels. So I do think, again, this comes back to that ensuring that properties are obviously in very good condition, that landlords are meeting their repairing and their compliance obligations, and treating tenants fairly. Because with 2 months' notice, if a tenant's not happy, they can leave. So we suspect that those tenants who were leaving immediately after the 1st of May probably have been wanting to leave for some time, or have seen more attractive properties on the market and didn't have to wait. But the fact, again, that it's stabilised in the last couple of weeks is reassuring. Tenants ultimately want a good home, and they don't want to be moving about every 6 months or so. So despite having that flexibility, which again I think is really important for tenants to have that if they're not having a good experience in their property, or do their life circumstances change, being able to move more easily. But at the same time, if a tenant does want to set roots and call a rental property their home for a long period of time, then it's really important that they have got a landlord and an agent who is meeting their obligations and doing everything as they possibly can to make sure they're adhering to the changes and the legislations. We have implemented a partnership with Rent Guarantor, so this will help in those instances where tenants who may previously have been relying on being able to pay their rent in advance. We actually have not seen a significant need for this since 1st of May, but yeah, we still are in early days. But it is a very good solution there for tenants when they need it. Typically, the fees are between 3 and 5 weeks of the rent, payable once a year, and up to 3 years of cover is provided for the landlord. There's also rent and legal protection there for the landlord as well. And the monetary worth for the landlord is £120,000 or 12 months worth of rent, whichever comes first. So that concludes our section.
Great, thank you very much. Lots of fascinating information there. One thing shocked me. I can't believe that half of properties in London are let without an agent, and I dread to think what that means for how the act's going to be followed. Before we open to questions, though, I have a question of my own to ask Donna and Wendy, if that's okay. Were we 28 days into the act? It was 1st of May, the act went live. Have you seen a shift in the market? And I'm curious what you think landlords are prioritizing. I always assume landlords prioritize maximizing rent, but now I'm wondering whether they're leaning towards minimizing risk. How do you see that?
I definitely think the minimising risk is the important factor here. We have been engaging with our landlords over a long period of time, preparing them for these changes. They know things about having rent and legal protection. They know about having robust referencing. They are being, although it's a competitive market, they are being patient to make sure that the referencing is correct. And they are being responsible in regards to pricing, not pushing us to go against our advice, because that is a change. We obviously used to say, well, this is what we think the rent is worth, and they say, we'll still put it on at X amount and we'll give it a try. We're not taking those risks because we want to make sure that we absolutely can provide that evidence where needed, and to protect the landlord, because although they may think that it's low risk, we definitely don't want to be operating in an environment where we're having the spotlight shine back at us, or the tenants haven't been treated fairly in line with this act. So far, it definitely feels like everybody is adhering to what we're saying. They're asking obviously lots of questions, but so far fairly stable activity.
Great, thank you very much. Right, we're going to open up to questions that are in the chat now. If you've got any questions, please do put them in the chat. The experts are here to answer your questions. I'm going to start the question from Natasha. I suspect this one's going to be for David, but please, anyone jump in if you wish to. Section 13 in tribunal, who pays for the costs and how long is expected until the decision is made?
The tribunal is a cost-neutral jurisdiction. So in a sense, everyone pays their own costs. It is possible to seek costs in exceptional cases if someone is madly unreasonable. The government has introduced a fee of £47 for tenants making applications to the FTT about Section 13 notice increases. That will be for the tenant to pay. The tribunal has a discretion to award it against the landlord on decision, but that will depend on how quickly it's all done. How long will it take? Nobody knows, because the government doesn't actually collect statistics on despite them saying
Strange
it takes
that, isn't it?
It's odd that, isn't it? Despite them casually saying in the impact assessment it takes 4 to 6 weeks. They don't know that for sure. And actually at the moment it takes about 2 months. But at the moment, or prior to on the old regime, you're only looking at 40 to 50 applications per month across the whole of England. So if there's still only 40 to 50 applications per month across the whole of England, it probably take about as long as it does now, which is about 2 months. But it might be more than that, in which case it will probably take much longer. How much longer, I can't tell you.
Okay, thank you very much. I guess we'll find out. Next question, short one from Bex, from Rebecca Ticehurst. How will stamp duty be worked out and paid? Who wants that question?
That's still to be dealt with. There is a problem in the because tenancies are now open-ended after if you do a series of renewals. So I do a 1 year tenancy, then another 1 year tenancy, then another one. You don't count them together, and so they're all individually considerable. So you're unlikely to meet the stamp duty threshold. However, if it's an open-ended tenancy, at the end of the first year, you have to recalculate the stamp duty, and you do that by adding together the rent for year 1 and 2. And if that takes you over the threshold, stamp duty becomes payable. Now, the government has said, and this will probably be resolved in this year's budget, that it will fix this problem so that tenants under assured periodic tenancies will not find themselves liable for stamp duty. I mean, in practice, no one ever pays it because it's completely unpoliced.
Mm. We always advise our tenants to pay stamp duty land tax.
I'm sure people are advised to pay it.
And we filed the form on their behalf. And my understanding aligns with yours, David. Although my understanding is at the moment, periodic tenancies would be treated as a lease for indefinite terms, and stamp
Yeah,
duty land tax is essentially calculated every 12 months.
yes.
Um, on the basis
But the
that
government's intending to
well,
fix it
they're
before
fixing it,
anyone falls foul of the problem. In theory,
in
they
theory.
say.
And so, in theory, a periodic tenancy that falls below the threshold over 12 months will never essentially attract stamp duty land tax, no matter how long the tenancy is in
It
place.
depends how they fix the problem. I don't know what their plans are to fix it. I mean, I imagine what they will probably do is dump an exception into the stamp duty land tax legislation, um, which says that APTs are just exempt from the payment of stamp duty land tax. But that will be for the Treasury to decide at whatever point.
It's fascinating to me that we've got this act and we're like a month into this act, and the answers are, well, we don't know yet. They haven't figured it out yet, and there's lots
Well,
of
I mean,
questions that
it's
are
madness.
unanswered.
It's madness to pass a piece of legislation that's not even dealt with by the Treasury that radically alters people's tax position, and the position that the government comes up with is, yes, we're going to do something about it.
Well, okay, we'll find out. A question from Debbie Bowker, quite a relevant one for her, I'm sure. With greater scrutiny of tenants likely, will this increase the typical time between making an offer and a tenancy agreement being signed off? And of course, she's worried about whether it'll impact on timings of school applications. Who would like that one?
Sorry, can you repeat that, Ashley?
Yeah, with greater scrutiny of tenants likely, will this increase the typical time between making an offer and the tenancy agreement being signed off? And Debbie is involved in school searches, and therefore she's worried about the impact of timing on school applications.
It's a good question. I can answer it from a tenant's perspective and from what we're seeing at the moment in practice, and then it'd be interesting to hear Donna and Wendy on the landlord side. The answer over the first 28 days of the legislation is yes, it is increasing the time. There is greater scrutiny, and we've had, I mean, anecdotally, because it's only been really 3 weeks, we've had a greater number of offers falling through and not being agreed. As to whether that's coincidence or whether that's really a direct impact on the legislation, I think it's probably too soon to say. But on balance, we feel that it will extend the length of time landlord will take to accept a tenant, but probably we're talking an additional couple of weeks as opposed to an additional couple of months.
Donna, Wendy, what's your side of things? How do you feel about that?
If everything is in order, then actually there shouldn't be any delay at all. I know that relocation agents are really good at preparing tenants to go through that referencing process. So anything you can do to get ahead of that to make sure they're absolutely ready for what the referencing requirements will be, then actually we don't see that much of a difference in the turnaround time of our referencing. Where it becomes complicated, of course, are those tenants where they can't default to paying the rent up front. And yes, as Marco was saying, we have absolutely seen a couple of deals falling through in recent weeks because there wasn't a mechanism available for them to move forward. But where things are ready and tenants and landlords are in a position to be able to move forward, we're not seeing a significant delay at all. So I really do think it's about just having that awareness and being prepared.
I think it's also the value that the agent adds as well with regards to really good calls of qualification with the applicant or the corporate partner, and just setting expectations around what information we need in advance, just so that we can try and reduce that time from finding the right property towards then going through the referencing and progression stage.
Cool. Thank you. Okay, got a beautifully niche question. I love this. I wouldn't have even thought about this. This is from Rachel Harvey. Tenants who previously had a military break clause allow them to terminate an AST by giving a notice of 28 days. Where do they stand now if they're redeployed at short notice? They still have to give their 2 months notice on the due date, or is there other legislation which means they can go back to being on 28 days notice? And does this apply to military personnel from any armed force or just UK military personnel? Does anyone know the answer to this?
Yes, I can pick this up.
Go
So
for it.
Section 5 of the Protection from Eviction Act was altered, which is what deals with tenant notice periods. And what it says is that tenants have to give 2 months' notice unless such shorter notice period has been agreed between the landlord and tenant in writing. Now, there is some dispute about this, but my view of this, and this accords with the government's guidance, I hasten to add, is that if the landlord and tenant have agreed a shorter notice period, i.e., by way of a military break clause, then notwithstanding the fact that the law has changed, um, then that shorter notice period agreement continues to be a valid agreement for the purposes of the amended Section 5, and therefore your break will be valid as 28 days. I'm aware that there are organisations who should know better, advising agents that all clauses are void after the 1st of May. That is not an accurate statement.
Okay. Thank you. Right. Sorry for the questions that have been answered. We've got time for one more before we have to sign off. I'm going to ask the question from Adriana. With the current changes in the market, do you think more landlords may start considering company lets instead? I think probably everyone can input on this one,
Yeah, I mean, I can
except for me.
obviously a company tenancy, providing that again they meet the referencing criteria just as they previously would have done. So that doesn't really change. Company tenancy is always an attractive one. Working with our corporate partners is always attractive for our landlords because they have got that extra reassurance and stability. They're dealing with professional tenants as well as having the support of the wider company or relocation agent who's working with them. So it's always been an attractive option, providing that the referencing criteria is met. And I'm sure that we will see landlords seeing that that is a more attractive option moving forward as well.
I have come across landlords who are requiring agents to advertise properties as company let only. It's not common, but I've seen it.
On our side,
Oh.
Ash, certainly we have been talking to all of our corporate clients with regards to company lets, and there is very little appetite to reintroduce really a culture of company leases in the context of the support that they provide to people coming into London. So whilst it is very attractive for landlords to have a company let, companies certainly don't see that as something that they would be wanting to give in addition as an optional benefit for people coming into London, with the exception perhaps of very senior people coming in. So certainly we have no expectation that on our client side, with regards to their employees in the context of corporate relocation, which of course is only a niche part of the rental market, we don't see that as having a significant bearing over the next couple of years.
It'd be
I've
interesting
seen
to see
a similar
actually.
issue in embassy lets as well. There used to be a position where embassies would often take in the name of the ambassador of the country, and there was a general move over the last 5 to 10 years to get individual occupiers to take things in their own name and reimburse them. There are still countries who take things in a corporate entity name or a national sovereign name, but most don't and are incredibly reluctant to change it. And of course, they're not going to change a policy that applies across the world merely because the UK has produced its own variant of legislation.
Donna and Wendy, you noticed from the comments, your colleague Chaz agrees with you on that one. So it's good that everyone's making the same line. Do you know, I said no more questions, but I have one final question I'm going to sneak in here, and that's for Marco. Marco, where on TikTok can we find the video of you and your daughter dancing in the kitchen that got 12 million
No,
views?
I'm afraid that's not something that I can reveal.
Okay, we're going to say big
I just
hardcore
want to jump
AI
in because
search
someone's
there.
popped up twice and said a company let can be structured as an AST depending on based on the nature of the occupancy. That's not accurate. A company let is a company let if the tenant is a company. If the tenant is not a company, an individual, then it's not a company let. So I'm not sure what this question means, but you can't structure a company let as an ASST or APT. I mean, you can have it let to individuals and the company is paying the money, but you can't change it by merely calling it something different. I may be unfairly jumping on this question, but it's just a point I thought I'd mention because it relates to this company let point.
Thank you. I'm afraid on that news, we're
Sorry.
gonna have to put that's you're very well. We're gonna have to pause it there. Important safety and legal advice from David. It's all very good. So thank you all the panelists and very insightful practical discussion today. Thank you everyone who joined. It's clear that the Renters' Rights Act is simply not a legal change. It's obviously driving behavioural and or operational shift across the entire rental sector, and of course that has a huge effect on the relocation industry. I think we found out that the role of agents and relocation professionals may be becoming even more important, and trusted guidance is probably becoming just as valuable as the property itself. At least we like to think so. We've also heard that while legislation introduces greater protection and opportunities for tenants, there may also be unintended market pressures. We're looking forward to see how those work out. Maybe reduced supply, more rigorous referencing, and upward pressure on rents. Of course, all factors that the industry is watching closely. And perhaps most importantly, there's still uncertainty, as we found out lots. So this is very much an evolving landscape rather than a finished picture. But what is clear is that the industry is entering a period where adaptability, communication, and compliance will be critical for everyone involved in our industry. Dom, before I close off, is there anything you want to add about where people can view this online going forwards, or anything else we need to be aware of?
Yeah, that's brilliant. That was really, really insightful. I haven't heard a webinar that's created or a piece of legislation that's created so much confusion as it's GDPR. Yes, this will be on YouTube. I will edit this down tomorrow, and Bryony will send the link to everybody, and the link will be on the ARP website.
Great, fantastic. Thank you. And thanks again to everyone who attended. We wouldn't be here without you, but we hope you found it useful. And final thanks, of course, go to our panelists, Marco from R3 Location, David from Bishops and Sewell, and Wendy and Donna from Campions Group. Thank you all very much.
Thank you very much.
Thanks, everyone. Bye-bye.
Thank you.
Bye.